Puan Hakim. I am Shakira Fatini binti Saharudin, the co-counsel for plaintiff. I will address the second, third, and fourth issues. Puan, the second ground for plaintiff's application for summary judgment today is because plaintiff in this case has successfully delivered the goods to defendant's registered interest. So first and foremost, we would like to draw court's attention to refer to plaintiff's statement of claim in paragraph 7 and 8, where it is stated that on 2nd March 2015, defendant had placed its order from plaintiff by way of purchasing order to their registered address at number 7 Jalan Duta Mas 4, Taman Duta Mas 43200, Malakong, Selangor. And on 6 March 2015, the plaintiff did deliver the goods as per defendant's order. It was further explained in paragraph 8 of affidavit in support, where on 10 March 2015, the plaintiff in this case had successfully delivered all the goods ordered to the defendant. We attach here with a set notification on successful delivery by email for reference of this honourable court, marked as Exhibit NQM4 in affidavit in support. As regard to defendant registered address, plaintiff humbly refer this honourable court to paragraph 10 of statement of claim, where it states that all goods had been consistently delivered to the same premises at number 7 Jalan Duta Mas 4, and defendant had never disputed this delivery address before this. Also, the honourable court may further refer to paragraph 2 statement of defence, where defendant in this case admitted the same, where they approved that the registered address of them number 7 Jalan Duta Mas. And may the court also refer to exhibit which tendered by plaintiff in this case in affidavit of service marked as MRI1, which where results from the registrar of companies dated 6 June 2020 of defendant company, which is Global Cable Solutions Sedang Berhad, stated that the postal address of defendant remained as number 7 Jalan Duta Mas 4. And now we move to the application of law, where in section 2 tag as S2 in plaintiff bundle of authority, section 2 of Sales of Good Act defines delivery as voluntary transfer of possession from one person to another. Goods are said to be in a deliverable state when they are in such state that the buyer would under the contract be bound to take delivery of them. Likewise, in present case, upon confirmation of purchase order placed by defendant on 2nd March 2015, plaintiff which is under such contract of sale is bound to deliver the goods. In addition, we would like to draw court's attention to refer to section 36 subsection 1 of the same act, which is Sales of Goods Act, which explain on the rules of delivery. Apart from any such contract, goods sold are to be delivered at the place at which they are at the time of the sale, and goods agreed to be sold are to be delivered at the place at which they are at the time of the agreement to sell. So this provision required the goods to be delivered at the place which has been agreed in the contract, where in our current case, the only registered address appeared along documents along transaction between plaintiff and defendant is only number 7 Jalan Duta Mas, Taman Duta Mas. Reference also has been made to some cases, which is in Siti Nur Aisyah binti Ishaq against Golden Plus Holding Berhad. Court may refer to C1 in plaintiff bundle of authorities, where Court of Appeal stated that in this case, the appellant is entitled to rely on statutory and official records containing the respondent business address at the KL address, and hence the address given by SSM is indeed the same address that the respondent stated in its last annual written file in 2010. The appellant must be allowed to rely on such information for the purpose of determining the respondent's place of business or business address. So by applying the principle that established in this case, plaintiff is correct in relying on information given by SSM, which is the company search that plaintiff conducted before, to determine the defendant's registered address. So if there is any changes for the address that made by defendant, it is immaterial to plaintiff. and the judge in this case agreed with the submission of learned counsel for the plaintiff that all that is required for plaintiff was to ensure that the demand letters were sent to the last known address of the defendant. Likewise, in applying to plaintiff case, the last known address where the goods were delivered is number 7, Jalan De Tamas 4, Taman De Tamas 4, 3200 Balakon, Selangor. So this is proven where the goods previously and consistently delivered to the same premises and never been disputed by defendant. Plaintiff also relied on SSM company search as the main document to prove that it was the defendant registered address. Therefore, on 6 March 2015, plaintiff in this case has successfully delivered the goods to defendant address, which is registered in SSM. Puan Hakim, I would like to continue with the third ground, which is all the goods have been received by the defendant through its agent. So we would like to refer to paragraph 9 of statement of claim and paragraph 9 of affidavit in support, where on 10 March 2015, goods were received by defendant's agent, in which the orders were duly signed and carried the defendant's stamp. And the agent who received the goods and put the signature on the consignment note is bring the name of Salwani. So this honorable court may also refer to a copy of receipt receiving goods carried defendant's agent stamp that we attach and mark as Exhibit NQM5 in affidavit in support. So the receipt or receiving good which carried defendant's stamp, agent stamp and bear the company name and address indicates that defendant had already received the good. Thus, the defendant could not deny from the facts that they have received the good. In addition, may the court refer to plaintiff bundle of authorities that as S2 Section 42 of Sales of Goods Act as regard to acceptance, deemed to have accepted the good when he intimates to the seller that he has accepted them, or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller, or when after the lapse of a reasonable time he retains the good without intimating to the seller that he has rejected them. It means that defendant is deemed to have accepted the goods delivered to its premises. This is due to the reason even after several letter of demand, which is first, second and letter of demands were made to defendant, they were not raising any issues on the non-receivable of the goods. Therefore, it indicates that the defendant had impliedly or indirectly received the goods, but they kept silent on it to avoid from having to pay the outstanding sum. So to clarify on this issue, we humbly requested this honorable court to refer to the case of Caltex Oil Malaysia Limited against Classic Best Berhad and others, tag as C6 in plaintiff bundle of authorities, where the court in this case looked into the facts and conducts of defendant to determine the non-receivable of good that have been contained by the defendant. But in this case, the court stated that the defendant had not questioned on the invoices that sent by plaintiff if indeed they have not received the good that they ordered or that they were invoiced for someone else's orders. It is only natural that the objection should have been raised there and then not after this action is filed. The same goes for the letters of demand sent by plaintiff. No protests or disputes were raised by the defendant as for the goods that the defendant alleged they have not received, nor debit note were applied for. So, in relying on this case, it is submitted that the defendant in our present case, which is Global Cable Solutions in Berhad, they didn't make any objection or question prior to this proceeding on the issue that the goods were not received by them. So if the goods were not received by defendant, they would directly or promptly object or make an inquiry on the issuance of invoice and tax, notice of delivery, and etc. As we attach in Exhibit 3 until 10 in affidavit in support. Therefore, we could say that the defendant, in fact, has knowledge that the goods were delivered and received by his agent. The last ground for plaintiff's application for summary judgment is that the defendant has not paid the outstanding sum of Singapore dollar 91,222 and 62, which is the same amount in ringgit Malaysia, 278,323 and 23 cents for the delivery of goods, including freight charges and duty tax. Puan Hakim, from all matter of fact that we submitted above, it is clearly proven that plaintiff has performed its obligation to deliver the goods as agreed in the contract. Due to that reason, there should be no hesitation on defendant's part to pay the outstanding sum upon. And as agreed in the contract, the plaintiff will keep running accounts of their business transaction and provide the defendant with account statement from time to time, and this account statement will reflect the value of the goods delivered, the payments made, and the outstanding amount due from the defendant. So, may court refers to paragraph 11 of statement of claim, where statement account that prepared by plaintiff shows that as at 31st May 2015, an outstanding sum of Singapore dollar 91,222 and 62 cents was due from the defendant. Likewise, in paragraph 13 of affidavit in support shows that defendant had only paid deposit of 10% of total purchase price, but not the remaining amount. We attach here a copy of account statement marked as Exhibit NQM 11 in affidavit in support for further reference of this honourable court. Due to this reason, as highlighted in paragraph 12 of statement of claim, the present suit was instituted after the defendant refused to pay this outstanding amount, even though after demands were made. In paragraph 11 and 12 of affidavit in support, the first, second, and third letters of demand were sent to plaintiff. So we attach here with and mark as Exhibit NQM 8, Exhibit NQM 9, and Exhibit NQM 10, which we attach this exhibit in our affidavit in support, where this honourable court may refer. This defendant in this case was actually given an extension of 7 days to settle the outstanding amount, but they still failed to settle the amount due. So now we would like to draw court's attention to refer to paragraph 10 of affidavit in support, where on 15 March 2015, plaintiff had already sent the delivery order together with invoice of purchase price, freight charges, and duty tax from barclays@gmail.com to defendant's email, namely globalcable@gmail.com. And the buyer shall be ready and willing to pay the price in exchange for possession of the good. Thus, after from this provision, after receiving the good, defendant should have made payment as an exchange of the good received by them. So this is supported in the case of Wasco Lindung Sedang Berhad against Last 3 Metals and Minerals Sedang Berhad, tagged as C8 in plaintiff bundle of activities, where in this case, the court referred to the High Court case of Popular Industry Limited against Eastern Garment Manufacturer Sdn Bhd, as his lordship then was Edgar Joseph, held in the High Court that in ordinary contract for the sale of goods, delivery and payment are concurrent obligations. As regard to the failure to make payment according with the contract, this Honourable Court may refer to Section 55, Subsection 1 of Sales of Goods Act, where it was stated that under contract of sale, the property in the goods as passed the buyer, and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may sue him for the price of the goods. So applying to the plaintiff case, it is right for plaintiff. It is a right of plaintiff to claim for the outstanding sum by bringing this present suit due to the failure of payment made by defendant. To support our submission, we may please the court to refer to Rainbow Enterprise Co. Limited against Step Auto Sdn Bhd, tagged as C7 in plaintiff bundle of authorities, where High Court in this case established that the invoices are documentary proof of the person who placed the order, and therefore obliged to make payment to the plaintiff in respect of the orders. This Rainbow case further emphasized that in a commercial relationship, the failure by a party to deny the demand made by the other party amounts to an implied admission. So it is the same which is done by defendant in present case, which is defendant Global Cable Solution. We apply to this case where they did not make any rejection as regard to the first, second and letter of demands which have been sent to them via email, and also invoices of tax, the goods. We support our submission by referring to the case of Caltex Oil Malaysia Limited against Calcit Bus Sdn Bhd, tagged as C6, where this is a High Court case. They indicate they refer to the case of Syarikat Pakar Kayu and Perdagangan Sdn Bhd against Mas Sdn Bhd 1986. Also a case concerning goods sold and delivered, where the High Court granted the plaintiff's application for summary judgment on the ground that the defendant had not raised any objection or queries, even though detailed particulars of the transaction were provided through the monthly statements of account. By applying to this present case, because of all documents have been sent to defendant, but the defendant had not raised any objection as regard to the document that sent to them, it is affirmed that they already accepted the goods and they have no rejection as to the amount that they have to pay. So in conclusion, plaintiff has established a prima facie case which is required under Order 14 Rules of Court 2012. Plaintiff also successfully proved to the court that defendant has no triable issues in order to proceed for full trial. All issues raised by defendant are merely denial of allegation, and they have no meritorious defense to dismiss plaintiff application for summary judgment. In any event, the mere denial as to the fact established by plaintiff should not be considered at all by this honourable court. It is respectfully admitted that defendant's statement of defence was filed only a tactical event to avoid from paying the outstanding sum, whereof the plaintiff prays to the court to grant our application for summary judgment. Thank you.